Well, we learned a few things, but they didn't accomplish anything, as usual. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. So some of you might have seen my community tab about the electricity doing crazy stuff today, and I didn't even think I was going to be able to screen record the hearing because I had issues. I was down and just like out for a few hours. This damn thing is long. This thing is like 80 minutes long, I think it was. And while, yes, there were a couple of details that were spoken about stuff that is new and interesting information, at least in my opinion, nothing really was accomplished. And I know that it's going to be out there like pretty much everywhere. And the clips of the things that are important is going to be what's in this video, if that makes... You guys get what I'm saying. Anyway, I'll explain what happened with the electricity and what I was told and blah, blah, blah for those of you who are interested in the updates on my life, which there's a few of you. So that's why I want to go ahead and put it at the end of this video. Let's go ahead and get started. This is how this is going to work. As I said, there are channels that live streamed this and they are all over YouTube. Okay. So this is not going to be the entire court session. I am going to be listening to it and reacting to it as I'm listening to it, but I'm not going to just have a whole bunch of like them talking only and it's just blah 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 that nobody cares about, you know. So it's going to be clipped and edited, and the important parts are going to be in here. So let's get started.
And I thought we should first go with the defendant's motion to allow experts and investigators access to view IGG information. Also, the motion to clarify sealed order for disclosure of IGG, and we're just into that. So go ahead, Ms. Xana.
Thank you. You're reading the state's response. I think the state has no objection to the three named experts having access to the sealed IGG materials or the materials subject to protective order. So I think what we're really talking about is our investigative team for Bryan's case to have access to the IGG materials. And the state has objected to that. They've objected in part because they are not named in our motion. So I want to address that first. Your Honor, they are not named, and I can name them, that's not a problem. But the reason I didn't is based on consistency.
What does that mean? The reason I didn't is based on consistency. Like consistency of your investigators or what? Because it seems like being consistent means being organized. I just know that in this argument, I understand why they're like, hey, we kind of need to know who you want to have permission to look at that stuff. Because look what's going on in Delphi. Okay? Stuff like this is important. And while, yes, I agree, things are crazy and wonky with this case, the defense also cannot just sit there and act like they don't have to do things the right way for some reason. And just like for the defense, she's, Ann Taylor's wanting to sit there and nitpick through all of the credentials of every little person that touched certain things. Like she has a whole list. We've gone through all of the people and all of the like personal details of all of these people that worked on certain aspects of this case and how she wanted to dive into their histories to validate that they had the right credentials, were the right kind of people to be doing the work, right? So for her to sit there and be like, oh, I want all of this from the state, but then be like, oh, well, I just can't right now. I just can't tell you who's going to have access to all of this because it all just depends. No, like you just can't do that.
Same investigators have had access to the grand jury materials to assist us in the case. They've had access to other things subject to protective order, and they're not named in those. They have access, there's three items subject to other protective order, and that's medical information from hospitals, that's University of Idaho records, and most recently police procedures. They haven't been required to be named in orders in any of those. And
so because they're not having to be named in those orders, she doesn't think she needs to name them in this order, and that's what she means by consistency. Or is it just laziness? Like if it's the same people that you've used all the time, then how hard is it just to put their names in there? This is just one of those things that the arguments are just so pointless.
Consistency, I did the same thing, but we can name them if that is a sticking point.
Then do it.
I would note that the members of the FBI that did the analysis are not named in the materials either. Your Honor, the
Okay.
reason why our investigators are important to have access to the IGG materials is because of the kind of case this is, and they help us understand things that are given to us by the state. They help us find witnesses, they help us find experts, and they're necessary to be part of the conversation of what the IGG materials are. And
you know, she's talking about Butanti. Like, I'm sure he's one of several, but that's what she means by investigators, in my opinion. I don't think she's really talking at all about people that actually are investigating the case from law enforcement perspective. These are like the defense's investigators.
what they need. This matters in figuring out how Mr. Kohberger ends up on the police radar and subject to these proceedings here. I know we've talked about this before, and I still don't have all of those answers. I believe today, with our experts getting access, we're going to make some headway with that, but we also need our investigators to be part of those discussions as well. Again, Your Honor, if their names appearing in a court order is an issue, that we'll do that. We'll do that. That's inconsistent with the other protective orders, but we'll do that.
It's inconsistent with what we had to do before, but we'll go ahead and do it if it makes you happy. Stuff like this, guys, like, I'm look, I've nitpick on both sides, so I don't hear nobody's bullshit. I really just don't. Both sides do stupid, redundant things to just waste tax dollars and billable hours that are completely just like time stealing. Okay. In my opinion, this is one of those things. Okay. If you've got the same people that have been helping you work this case the entire time and you know the exact names that are needed, you've already known for like a few weeks now that it's a problem. We went over the document here. Okay. So for her to come into court and be like, if that's really a problem, then we can do that. You know, it's an issue. We can just handle it already.
And they'll be subject to the protective order just like we are, and they'll abide by it just like they've done for the other protected materials they've had access to.
In the defense's motion, their stated reasoning is, quote, to investigate how and when Mr. Kohberger was identified as a suspect, end quote. State maintains they don't need access to all of that highly sensitive information to satisfy that purpose that is laid out in the November 28, 2023 letter from the FBI to the state.
Okay. This is the Twoy letter. Now, I mentioned this in a video and I didn't know what the hell it was, and I should have done a video by now. I need to do that. I will do a separate video to like explain what I found about what this actually means. There's just so much to talk about. I always forget about like filling in the gaps of stuff. Anyway, the Twoy letter is not really like a letter. And the way that it was described to me is that it's more like a request. And there's a reason for it. There's a whole background to it. It came from a case situation, an inmate, I believe it was either in Illinois or Florida. I don't know why I'm seeing those two states in my head when it comes to this. I want to think more on the Illinois side for some reason. Anyway, we'll get into that. Like I said, in a separate video, I'll go over what the whole like Twoy thing actually factually is. Okay. But according to what I found, it's more like a request. And what this letter is that they're referring to is really just the response to the request. It's not really called a Twoy letter. It's called a Twoy request. And then you respond to said request. Okay. So I don't know exactly what they're claiming is in this thing, but the whole thing that the feds and the Department of Justice has claimed this whole time is that they legally do not have to hand over any of this. They legally don't have to keep anything, blah, blah, blah. It's all these arguments about what they're supposed to actually keep when it comes to producing the work that was done to come to their conclusion, right? The problem is that it's all gone. They've deleted the profile out of the system that they used in the first place, so nobody can double check this work. Now, they can double check it, but they would have to do it all over again and hope that they get to the exact same result. Now, if they were going to do that, they should have done it already, because this has been a problem for a long time now at this point, where they could have gone back and redone this test several times to make sure that the DNA results, the family tree results, all of the things come back the same. Why they haven't, or, you know, maybe they have and we just don't know, but it seems to me like they haven't. I don't see how they could, honestly, because there was already, you know, with it being touch DNA, they would literally have to start from the beginning, which is going back to the original source and pulling whatever sequence they can off of it and literally starting from scratch from the DNA sample itself. That's the only way to truly double check the work here. So I don't know exactly what this Twoy letter, Twoy request response thing would actually lay out, other than like the basics of what we kind of like already know. Othram had it. FBI decided to take it over, told Othram to stop, send everything over there, and suddenly they put together this little family tree and called Moscow PD and said, hey, we're sending over this family tree, your guy's in there somewhere. I mean, if that's literally all that it says, then again, nothing was accomplished, and there still really is not any answers at all.
But I allowed access to what I thought was potentially relevant, and to allow your experts, now allowing your experts to view that information.
What he thought was potentially relevant. Now, I want you guys to remember that because we discussed this. We discussed this in, I think it was my last Idaho video. Yeah, my big one, whenever we went over the article from the Idaho Statesman. Now, if there is a possibility that the IGG information was obtained illegally, like we've heard rumor was the possibility, Judge might have noticed it and might have felt like it was needed for the defense to know that information and might have sent it over, or he might not have. Like, we don't know, and that's why it's like a sketchy situation, because the prosecution has the whole thing. Now the judge has seen the whole thing and the defense is only allowed little pieces of it. And I just don't understand how that's like fair at all.
So my balancing responsibility is to keep it in control to some degree. So I guess what I'm asking is that I have some justification for making contact with certain families that may have no bearing whatsoever on the case, unless it's in mitigation or something like that. Now,
certain families that don't have like anything to do with anything. Okay, well, those families would only be on there if they were part of the family tree. But the part that I'm not understanding is, why would any of those people need to be freaking contacted? Like, if they're just like fifth cousins on someone's aunt's side of the family or some crap like that, why would those people need to be contacted anyway? That seems like it'd be like a waste of time.
I was talking specifically about people that are already known to our team that we may be in contact with, friends, direct family, parents, sisters, aunts, and uncles.
and
Those
I interrupt you just for 1 second. That has no relevance to the IGG information that you were given.
Those are people we already knew before.
Are they dumb? Like, how smart are these lawyers? We over here, just on the YouTube people, right, already knew that's what the frick they were talking about. They literally laid it out so freaking clear a couple of weeks ago. I said this on this channel. I said, okay, so the way that it sounds is, if they already have these people's contact information and they already had their name written down somewhere in the paperwork prior to receiving their name on the IGG stuff, this was irrelevant to them. But if this is a brand new person that the defense did not know about until the IGG stuff was given to them, then this falls under that classification. Why are we needing to clarify that? If I can understand it, if us non-lawyery people can understand it, and this chick has been a lawyer for a really, really, really long time, and these other people that are lawyers with her have also been lawyers for like a super long time, why in the hell are they needing clarification on something that seems pretty freaking cut and dry? If you had their information and their names and knew that you needed to talk to them prior to the IGG, you're good to go, no problem. If you didn't know these people until you had the IGG, then there's protocol to follow. I don't understand why. See, that's what I mean. This is more instances, in my opinion, of tax dollars being wasted and billable hours that are being paid for no reason. No relevant reason at all.
Okay. So I want clarification that I can continue to talk to the Kohberger family.
Yes.
I want to make sure I'm not running afoul of court order. And I want to be really clear who I
Is Judge even like looking at her like, are you for real? Like, I'm seeing him like smirking. He's looking at her like, yeah, duh, chick. Like, come on, come on.
I'm asking for to have access to the IGGs. It's not our mitigation investigator. That our mitigation investigator, I think the court heard me talk about going 3 generations back to do her work. That's required under the AVN. I'm not talking about her. She wouldn't have access to this. I'm talking about our criminal investigators dealing with the innocent space for Bryan.
Okay, so if for the mitigation, and this is another thing that we've talked about before, and something that we also know from covering the Megan Stedman case is also happening with Chris Foyles' death penalty case, they have to do like 3 generations back, but it's immediate family. It's not cousins and uncles and aunts and stuff like that. It's dad and mom and grandma and grandpa on both mom and dad's side, and then that set of parents, like the great grandparents and stuff like that. It's not all of the extra family. It's immediate back 3 generations, and that's it. So if this mitigation person is creating a family tree, be it a small family tree, because it only has to do like the very specific like bloodline strength back a certain amount of generations, couldn't they still branch out from that and see if they have the same results? Are they not like cross comparing like names from the IGG results versus names that they're finding doing their own family tree work? I mean, you'd think, right? Like you would think.
Our criminal investigators that are going to be dealing with our innocence phase of the case. Those are the investigators that I'd like to have access. They're the investigators that participate in the meeting with our experts. They're the investigators that help us put the timeline together to understand different things that were happening in the case before Bryan's name was ever spoken by anybody. And we're missing that big piece about why was Bryan's name.
Okay. Question. Because I heard this earlier and I was like, that's weird. So are these investigators that are actually like law enforcement investigators actually? If they were working on the case prior to Bryan's name being known? Because if she is like the defense attorney, why would she have been like working with investigators prior to Bryan's name? Unless they just had her like on the ready and being like, hey, whoever we bless for this, just be prepared because you're their lawyer. But because that statement just makes like 0 sense to me, and I could just not know how things work, but I don't understand why her as a lawyer would have been touching anything before she had Bryan as a client. If that's like, I might just be hearing it wrong. I don't know.
Name spoken and how does that connect to the other pieces that we have? That's what our criminal investigators are going to do. They're not looking at IGG materials, if allowed, to do any of the mitigation work. That's separate and apart. So I want to make sure that that's really clear. I can see how, I think, this is why I'm really happy to have our experts involved, but I can see a way that there may be a motion practice that happens that relates to this. I'm not there yet.
That's where I am.
A motion of practice that happens? I don't know what that means.
Because if you have these experts, okay, go through this. I've been through all this information. And
we know.
So if you can go, using your experts, and your experts kind of can tell me and state that you need to investigate particular people, okay, that were involved in this.
Okay, particular people. There was already a whole list. I just said this. There was already an entire list of particular people whose credentials and backgrounds and all the things that she wanted already. So when it comes to this, does this mean particular people on the IGG family tree itself? Because that could also like lead to a bigger suspect pool if that's the way that they're trying to do that whole thing.
And we can have a hearing about it. But I'm not quite ready to be convinced that without getting this information from the experts that we're going to find some pathway, okay, that's going to be helpful to Mr. Kohberger.
What this means and how our client came to the attention of law enforcement, and to plug things into the timeline of us trying to understand how we got from November 13th to December 29th. That's it. Not to go out and try to talk to people. I can just see that there's a potential motion to be filed, but that wouldn't be contacting anybody at all. That'd be a motion.
That's reassuring. I mean, that's one of the concerns. I mean,
I'm not understanding. I'm going to have to listen to Lawyer or somebody that's a lawyer about this, because I'm not understanding why she's talking about having to file a motion, but then saying it's not going to have anything to do with talking to anybody on the IGG list, when I thought that the whole point is that they were going to have to file something to show like relevance and reason for why they would have to contact anybody on the IGG list. I am just maybe not all the way awake, because I'm not really quite understanding the arguments. Not really the argument, but just like the conversation. I'm not understanding the context.
Pulling a lot of other people into the case that are completely innocent and don't even have any connection to the situation. So
okay.
Let me go back to Jennings. Do you have any response to any of this?
No, Your Honor, I'll just reiterate that Ms. Taylor keeps discussing their ability to just understand the timeline. Again, you're very familiar with the materials. Understanding the timeline and how we got from November 13th to December 29th is all laid out in that letter. None of the other materials are going to answer their questions regarding the timeline.
Now, if there's anything specific in that letter, then this is just going to be like more proof that Ann Taylor is wasting people's time. But we don't know because it's sealed and we have no idea what the letter says. Actually, it's not even sealed. I don't even think it was even filed. Now, something was filed. I added this to my community post. I think it was yesterday. Something was filed in the case summary, and it's like a sealed protective order for something. But I checked before I started this video, and I didn't see anything. I'm going to check again before the end.
I don't know how to tell you. It wasn't when I asked them in the hearing, did you use the IGG, any of the information of the IGG to get the warrant, to get Mr. Kohberger's DNA? That was not part of it. So in terms of the time frame.
Okay. This is how I see it. We know that Dawn Daniels asked the courts not to consider the IGG and the DNA blood work that she was told about by agents, okay? When it came to the search warrants for his apartment and his office. But for him to say, oh, they told me that, the IGG wasn't used for, obtaining the arrest warrant or for getting Bryan Kohberger's DNA. Okay, but it was still discussed. It was still a known fact. But just like whenever you're in a courtroom, if somebody says something while they're on the stand being questioned and it's a jury trial, and then the judge is like, oh, objection, allows an objection and is like, okay, yeah, strike that from the record. The jury just can't like erase their brain, bro. Okay. Whatever was said was freaking said, and it's going to stay in their head. So just like it's the exact same situation like this. Just because they might not have like typed it into a freaking document doesn't mean that it wasn't considered whenever they were doing the things that they was doing. Okay. That's so stupid to think that humans actually work that way because they just freaking don't. And it's just like with now Judge. He has now seen IGG information that the defense has nothing. They have nothing when it comes to the IGG versus what he saw, because he saw everything. And he's even sitting here claiming, yeah, just the parts that I felt were relevant. Well, where's the experts that he was supposed to get? Because the way that he's like said certain things is like, well, maybe your experts can help me understand it. Okay, well, I thought that that's what you were supposed to do, broski. Wasn't that the conversation that was already had? Was that you were going to bring someone in if you completely had to, bring someone in that could help you understand what you were going over? Because how are you supposed to know what's freaking relevant or not unless you know the science and what you're reading? Am I thinking that incorrectly? Because I feel like you would have to have some sort of actual background and some sort of knowledge at what you were looking at in order to make a real judgment on what was important enough to pass on to the defense and what was just rubbish, not needed. Ugh, anyway, all right.
Don't know that it's that complicated.
Ugh.
Because a lot of what happened in the time frame happened before that. Now, that's up to you to dig into that, obviously. But there was a lot of information in the letter, too. Just that was not part of it. So in terms of the time frame, don't know that it's that complicated. Because a lot of what happened in the time frame happened before that. Now, that's up to you to dig into that, obviously. But there was a lot of information in the letter, too. Just their sequence of using the IGG at all.
So does that mean that there's like an actual timeline and dates and what program was used and what and when? Because if they would just come out and be like, yeah, we got this letter from the FBI. They got everything from Author on this date. They started running the sequences on this date. They worked on it until this date. And this is the date that they came to their conclusion and sent the information over to Moscow with some work shown. That'd be beautiful if that's what this letter says. That's what this letter shows. And just like, Judge got to see all the IGG, he's obviously seen this too, because he can't sit there in his chair and say, oh, there was a lot of information in that letter, unless he actually saw it. Damn, I wish I knew what it said.
So we're going to have to sort this out, obviously. But going back to what I'd like to do is just get some justification for digging in deeper, if necessary. And I'm not sure it's necessary, but I'm going to keep an.
It's a death penalty case, and there's no need to dig in deeper. Okay.
Yes, Your Honor. Our mitigation expert has done her own family tree based on her work, and she has nothing to do with the IGG material. She's not an expert that would have access to that. She's not named. So she needs to keep doing what she's doing as far as her work goes. And I think the proper clarification is that the IGG materials will not be used to develop any investigative lead.
What if Vargas isn't being named in the paperwork for the experts that they want to look at the IGG stuff because she's the one doing the mitigation family tree? Maybe.
I think that's fair. And what Ms. Jennings proposed in language in their response to your motion, is that something that you would object to at this point? I'm sure she probably read that.
I did read it. It's a little bit less straightforward, but I think it covers it. It allows me to continue to speak to the people I'm speaking to and that I need to speak to that are on my list.
You could have done that anyway.
Okay.
We all knew that.
Anything else about that?
No.
These issues. Okay. Ms. Jennings?
No.
Okay, great. Mr. Kohberger filed for a permissive appeal to the Supreme Court. And I just wondered what you know about that, because I have heard nothing about that. I know it was filed.
So something was filed with the Supreme Court. We don't know when, but it would have had to have been between the 26th of January and this morning. Now, this should be to get the grand jury indictment thrown out, because that's what the motion to dismiss arguments were all about. And it was mentioned on the 26th that the Supreme Court was basically the next step. Now, I remember throwing a fit and being like, are they really sitting here asking the court for permission to go to the Supreme Court? Because I thought the whole reason for the Supreme Court is because the lower courts were being not okay or not doing their job correctly. So why would you need to ask permission from the court that you're basically claiming is doing something wrong? It just seems so dumb. But it's really just a heads up. But we know that they have these conversations in the background. So I guess it just has to be on court record that it's being brought up or whatever. But it'll be interesting to see what happens, because at this point they don't have an answer. So it's been filed. They just don't know if it's been accepted yet. And no one's heard anything from how it sounds.
I know the state's filed their objection, and that's the last that I recall seeing about it.
Yes. So at this point, we don't know if the Supreme Court is going to take it. Okay, we don't know. You know anything else, Mr. Thompson?
Not other than the state's response was filed by the appellate division of the Attorney General's office. I think we're just waiting to hear from the Supreme Court at this point.
Correct, Your Honor. We're just waiting to hear from the Supreme Court. I can tell you there's no deadline in the rule for them. They didn't include a deadline for themselves. And in my experience, it can take anywhere from a couple weeks to a month or so. So at this point, we're just waiting to hear.
So I don't know the answer to this. If it's filed, does that pause what we need to do here, or do we just pause it only when they pick it up?
My read of the rules, Your Honor, is the latter. That we continue as we are unless and until they decide to take it, and then they would decide at that point what exactly is paused and not paused.
Wouldn't a judge know that? He's been a judge for a while, hasn't he? Has he never had to do anything with a case that involved the Supreme Court before? I know I don't know the answer to that question, but for him to be I don't know how this works. What's the procedure? This seems a little odd.
Okay, thank you. Well, my interpretation was that they were going to give us a lot of information, affidavits, maybe testimony for the hearing. Is that right, Ms. Taylor?
Your Honor, you're right. The motion was to put everybody on notice that we'd like to have this addressed. We do intend to have a presentation for the court. We do intend to have briefing for the state. I anticipated we'd get that scheduled today. But no, I didn't file the motion. I filed it to put everybody on notice that it's coming, and I think we need to address it. I think we need to address it before a trial setting. It doesn't make sense to set a trial, get right up to it, and then have to have everybody who's under subpoena rescheduled and have to have the public and the families of everybody disappointed because we're going to reset it at the last minute. So I think we should.
I understand that. That makes actual sense. I don't know if they're going to change the venue. I honestly don't know if it would matter if they change the venue or not. I don't know. I don't really know a lot about the dynamics of that kind of stuff. I don't know. But she's right, because if they we're already arguing about, oh, it has to be around like the college schedule. And I was like, okay, well, that's so stupid because y'all want to file a change of venue. So it's not going to matter. It's not going to matter about your college schedule, your local schedule. You're going to file the change of venue. Why are you arguing this? It's pointless. It's redundant. And it's sort of the same. It's the same thing here though, because you don't really know what a jury's going to do. And I personally just don't, I don't know. I just don't, I know there were issues in Scott Peterson's case when it came to a jury chick, I think, or maybe there was like more than one jury person. And I know there's been a couple other problems in some other cases, and you really just don't know. But people also like lie to get on juries. They'll tell you what, they'll say what they think the court wants to hear just so they can get in the spot. And we just don't want that kind of crap to happen either. But that could happen anywhere, whether it stays local, whether it moves somewhere. I mean, I don't know. But Ann Taylor's right. You can't say, okay, well, we're not going to change the venue and we're going to get really, really close to the trial date and it's going to get through, get to the point to where we're going through the jury pool and we can't find anyone that fits the correct criteria. And we're going to have to move this damn thing now because the jury is tainted here. We can't use it. And then everything gets messed up all over again. How much you want to bet that's what ends up happening? That's probably what's going to happen with the way this case has been going.
Should take care of whether or not the court should change venue sooner rather than later, especially given the length that this trial is anticipated to go. We'll need to schedule a courtroom either here or in another county in Idaho. I mean, we'll need some advance notice to get that done because it'll take a long time to try this case.
Thank you, Steve. Thank you, Ms. Beatty.
And Your Honor, the state is asking for a briefing schedule so that we're not in a situation where the state is learning for the first time during a hearing what experts the defendant might be calling and what their arguments are. We would ask that all of that information be disclosed prior to hearing, including the CVs of any experts that will be testifying.
Okay, but can't the same thing be said for the frickin' IGG information? How is it any different? And also, isn't it like not okay now at this point that Judge has seen things that the defense hasn't seen? So would it be a change of venue that's the best thing to ask for? Or would it be a change in the judge? Because now he has seen actual evidence in the case that the defense doesn't have. Therefore, he has something in the back of his head when it comes to him making any decisions as well. Like, I know this is going to be a jury trial, and it's not going to be the judge that makes the decision on innocence or guilt. I understand that. But he still has to make decisions on things up until that. And now he has other information that might sway his decisions. Oh, yeah.
Well, that's certainly what I would have said. But it's quite sticky, right? To think, you're going to wait until it's ready to seating the jury, which is probably a 2-week process in this case. And then figure out, hey, we can't see the jury, so we have to move the trial. At the same time, how do you really know if there's some prejudice without trying to see the jury? It's really a catch-22.
Yeah.
And all of the logistical concerns that Ms. Taylor is describing are totally correct.
Okay. This morning I was looking at State versus Haddon, where that was, you're probably very familiar with that, but that's Court of Appeals case, 2012, I believe. And there was a request to change venue well before the trial. The judge denied that. It came up again when they were trying to seat the jury, and the judge denied that at that point. But kind of a double step to figure out if it was necessary. Now, that doesn't mean that one of the parties can't present evidence. And the standard is kind of squishy, in my opinion. But
the standard
they
is
provide that kind of
squishy.
information well before the trial.
I'm squishy.
At the same time, I want to make sure that the state has the opportunity to respond to whatever information Mr. Kohberger is going to present first week of May. Does that allow enough time? Does that allow enough time for you, Ms. Taylor?
Your Honor, I think it does.
Your Honor, as far as the duration of time between the briefing and the hearing, the state has no concerns about that.
Well, let's explore that just for a moment, because I've been thinking about setting the trial. Well, also for months, but I listened very carefully to Ms. Taylor and Mr. Thompson in our last hearing, and I've really it wasn't clear that I'm not really happy about setting the trial in 2025. It seems so far away. Now,
It
it's
is.
not just, doesn't just affect Mr. Kohberger and his defense, but there's a lot of other considerations. So I am trying to be fair and realistic, okay, about when we could really be ready for trial. Now we want to do it once. Okay. So let me go first to you, Mr. Thompson, about when. I know that it's been complicated, the discovery. I mean, you have these different agencies, FBI, state police, the state lab. We've got Moscow Police Department, Latah County, Pullman Law Enforcement, Pennsylvania Law Enforcement. And I think you mentioned it's hard to get all this stuff together. And that
There's
is
a lot.
one of the, I'm kind of curious, okay, when do you think that you will be completely finished with providing discovery to the defense?
Judge, most current projection that we have would probably be at the end of the summer.
End of summer.
The majority of the discovery has been provided. We filed our motion for trial setting scheduler back in December a couple months ago. We felt that was realistic, and as we are looking at where we are right now, I'm not sure that it is.
No, they're
we
both
know
agreeing
that
to
the
push
defense
it.
has already indicated that just on the death penalty alone, they will be filing multiple motions, and we actually have a proposal to make to the court for a trial date and a scheduling order, if Your Honor is interested.
I'm very interested. I'll tell you before you say anything about that.
Yes,
I was looking at whether or not it was realistic and fair. Okay, you know, trying to be compromising to some degree. I think it was March 3rd, 2025.
Well, Your Honor, just happens to be in pink highlight on my pad here, March 3rd, 2025. For trial.
Okay, I had no idea. I wasn't reading
Look
your
at
mind or
that.
anything, but I thought that's about the mid. And I remember, Ms. Taylor, that you said that would be the soonest you could be ready.
And that was if everything went right from that point.
And I remember that
And
too.
it hasn't. It hasn't. But I'll hear what their proposals are.
Okay.
I've heard the court say the court only wants to do it once. And I've heard the court ask, what can I do to speed things up? I need discovery. I need all of the discovery. I need the things that we've asked for. I need to not have to fight in motions to compel for things that was done on behalf of the state by the FBI that ends up being used against Bryan or used in the investigation. I need that stuff.
The IGG, the cast information, so many things were not done by the state. So many things were not done by the actual investigating agency. So many things were not done by Moscow PD. That's the biggest like hiccup out of this whole thing, is that so many agencies dipped their toes in this. It's just a huge cluster F.
I need, when I ask for something, I need to get it rather than have to go back and ask again. And I'm not saying anything mean about Bill Thompson. I'm just not. I think he tries his very best, but I think he's hampered by the agencies and the information he gets from them. I can give you some examples. We asked for x-rays. We were told they don't exist. They're listed repeatedly in reports. We asked for them again. And I'm not sure if I'm getting them or not. The response is we have thumbnails, but we haven't found the actual x-rays. There's one.
X-rays. X-rays are for bones, majorly. So that's curious. That's really curious.
I asked for.
Oops. I wonder if somebody had something broken. More than one person maybe had some broken bones. Or maybe even pieces of the blade, maybe. Because x-rays are very specific. So that's interesting. It's interesting.
Certain mapping data done by a member of the cast team. They said, you have it all. I said, no, I don't. I only have November 29th. And they said, oh, well, I guess.
They only have November 29th cast information? Okay, but November 29th is the date that, per the exhibit, okay, is the day that the security officer at WSU went into the registry, found that there was a white Hyundai Elantra that was owned by Bryan Kohberger. And then 30 minutes later, somebody else that works for WSU area officers went to the Steptoe Apartments. That's the right name, right? Went to Bryan Kohberger's apartment and saw the white Hyundai Elantra sitting there. And this was like at midnight. This was like literally around midnight, and then around 12:30 is whenever the other officer actually put eyes on the car in the parking lot of Bryan Kohberger's apartment. Why would they have cast information for November 29th? And why would they only have freaking cast information for November 29th? They were going to go. Hold on. So they really did just like go in front of a grand jury and have cast information presented as evidence to these grand jury people, and it was for one date and one date only, and it wasn't even the date of the murders? What? You guys know that we were supposed to have trial like 5 months ago. And this is the kind of information that they have right now? Are we got to be shitting me.
When I look in a folder, it has subfolders. And I might get some reports from Moscow Police Department with an FBI report. And an FBI report might reference an email. It might reference a photograph. It might reference a screenshot of a picture or of a phone that they took when they interviewed somebody. That's not with it. So maybe a few months later,
Okay, well, that's actually really specific. That's really super specific. So there's pictures taken from investigators' phones of the screens of other people's phones that were being interviewed. Did I hear that right?
I get some photos that has these screenshots in it. And now I have to try to figure out who gave that screenshot, whose phone did that come from, which officer did that interview, and get them matched up and figure out if it's somebody I need to talk to.
Okay, so that's what she's mentioned before. She's mentioned this before about how it just comes to her like all willy-nilly, and you can't like figure out who took, like, how did she put it? You know what the photo is, but you don't know who took it, the date that it was taken, and like all of the actual information, all the data that's needed. And all of those things are very specific and all very much needed in a court setting. Okay. Literally, it seems so tedious, but it is literally how it has to be. And it has to be all originals. There can't be any doctoring. There can't be anything on it. It has to be completely original. There can't be any problems whatsoever. So she's saying there's a bunch of screenshots like that because they interviewed a bunch of people. But what would they have screenshots of? It almost makes you wonder about the like whole conversation on Snapchat situation. But I just don't think that the situation is as deep as everyone tries to act. I think there probably was a bunch of messages through Snapchat, but I think it was maybe like a half hour before the 911 call. I don't think it was as dramatic as everyone thinks. I still think there's some shady stuff going on with Dylan and Bethany. But hearing that there's screenshots of pictures that were taken that are not labeled, not marked, and having to like be sorted out and gone through, it really just makes your mind swirl a bit.
So not only do we have a huge volume of information, the way I get it is completely disorganized. And it's like if you wanted to play 52 card pickup with 100,000 decks of cards and throw them in the air, and I have to go figure out how to put them together. And by the way, the backs of every one of those cards look the same. That's what I'm doing. We also have science questions in this case. We have DNA, we have cell phone analysis, we have video analysis. The video analysis that the state really likes in this case, I don't have the full scope of that video with audio that should be available. They're working on it. They really are. I don't think they're not working on it. I'm just saying this is a real thing that takes time.
If it's a video, why do you have to piece together the audio and the visuals? Isn't that what normally a video is? Why would you have to piece that together? We discussed this because she said something very similar to this in the January 26th hearing. And we have not been able to figure that out yet because I honestly don't believe that anything on the Linda Lane crap is evidence. All right. If it was truly evidence, then the feds would have done what the feds know how to freaking do and erased it off the internet by now because they can do that like that. Okay. And it's not. It's circulating out there. There's conversations about it being circulated out there between TikTokers and family members. Okay, it's out there. The damn thing is still out there, and it's still causing freaking chaos. If it was evidence, if it was admissible, it wouldn't be out there. So if they actually have footage like they're claiming, then why are they having to piece it together? That's literally, to me, like they're creating it.
And then you have the public nature of this case, and people don't want to talk to us. They're not willing to talk to us. So we have to try to get witnesses, people that are listed in the state's discovery, to talk to us. We have our duties that are required with mitigation because there's no break. I don't get to go to trial on the innocence phase, and then if something goes wrong and Bryan's not acquitted, I don't get time to go prepare that mitigation. I have to take another breath and start right there. So I have to have time to do all of that. Our mitigation expert is working.
Oh my God, my computer's tripping. Y'all heard that, right? She just said, I won't have time to go fix that medication. Probably because you're going to be having a freaking panic attack. I don't know, this is funny.
I still need to read every bit of discovery that's come, and I haven't. I scan it when I get it, but to go page by page and read it and understand what it means, I'm not through 2023. I have a long ways to go. So I don't think that that is realistic to set it. I think if you...
Chick, you've got one job. You've got one job. You're handling one case. And I don't want to hear nothing. She's handling one case. They're not going to have her doing multiple caseloads with how extensive this case is. You've got one job, Anne, to sit your butt down and go through the discovery and figure it out. So I don't understand what's taking so long. Okay? Because how are you going to sit here and say, I've barely gotten through 2023? This crime happened in 2022. The only evidence that matters is what happened, like she said, between 11/13 and 12/29 of 2022. They're doing nothing. I feel like they're literally doing nothing.
You set it for March. I'm going to be back here after the discovery deadline, and I'm going to be telling you there's no way that we're going to be ready for trial. I would rather this court set the change of venue, make that determination. Let's see where we get with the discovery by May. Probably the court would have a decision by the end of May, early June. Let's see where we are with discovery by then and set a realistic day. I hope we can go by summer of 2025. We should be in good shape by June of 2025 to try the case. If we have that discovery come up, I think that's a great idea.
She's such a kiss butt. I don't know why she keeps saying that so much. It's such a great idea. Such a great idea. Such a great idea. It's honestly just getting on my nerves. I just felt the need to say that. I'm tired. If you guys haven't noticed, I'm exhausted. I barely slept last night. For some reason. It's actually been like a couple nights. Haven't slept very well. Like a situation happened and now my PTSD is just like raging and I'm not sleeping very well, so I'm tired. And then going back and forth with my grandma, I'm just like super tired. I'm only explaining this because I know my eyes are sort of like burning a little bit, and so I know that like my eyes are like closed some, and I've got lights like right here, and I've been staring at a computer forever, and then I'm stressed because of the situation with the electricity earlier. My eyes are burning. I'm tired. I'm just letting you guys know that's what's happening here.
Mr. Thompson?
Trying to figure out where to start first. Yes, discovery is fast. Yes, there have been things that Mr. Kohberger has asked for that we've inquired, and we were initially told, no, you don't have that. And then we have gone back at the prompting of the defense saying, you sure? I mean, it ought to be there. And for example, x-rays for the autopsy. Well, we just got those. The first came in with thumbnails. In today's discovery, Ms. Taylor's going to have the full size, which we were able to obtain. We saw he gave us thumbnails. These are useless. Give us the real thing.
Today's discovery. So as of the end of this court session, and as of right now, as I'm speaking, she should have the x-rays. The defense team should have the x-rays in their possession. Okay.
It's going to benefit to have deadlines for everybody to have to work for here. I don't think just setting a deadline for state's discovery does anything other productive other than that initial stage. So if we're
I just don't understand why all these deadlines are even necessary. Like, you have one job. And your job is to prove your case, just like the defense has one job, and their job is to defend their client in the case. Why does there need to be deadlines for stuff? Shouldn't they be instantly just trying to do this as accurate and as fast as possible? It's like you have to give them a homework deadline like you do a little kid, just to validate the fact that, oh, if you go ahead and put some fire under their butts by giving them a time that they have to aim for, then they're going to get their job done. But if you don't give them a deadline, then they're just going to dilly-dally and not really care. It's just all so stupid. There should be a deadline just like altogether. Like, I know that there's like stipulations for speedy trial and like lengths of time after you are charged that you need to be like put in front of.
Right, set discovery deadlines. We need a state's discovery deadline. We need a defense discovery deadline within a reasonable time after that and a reasonable time before trial, because we're going to then have to investigate whatever the defense tells us they might be using. And then, of course, an opportunity after we see what the defense is proposing or is disclosing to rebut that in some fashion and give notice of that. And I think the last thing that I want to touch on real quick is the proposal to set a state's discovery deadline and set hearings on the change of venue is inadequate. As we've indicated, change of venue under the law, that motion is premature. We know there's publicity. Everybody can agree. There's been massive publicity, not just in Latah County, but I see more about it in Boise or hear about it from other parts of the state than what we're seeing
All
locally.
over the world, broski.
So the massive publicity, that's a red herring, realistically. There's publicity everywhere.
How is the amount of publicity in this case considered something as like concrete definition wise as red herring? A red herring is literally something that is thrown into the mix of facts that looks credible but leads you down a rabbit hole that is not true. How is the publicity in this case a freaking red herring? It's not a myth. It's not something that's being thrown into the facts that's not truthful. This case is worldwide. Worldwide. Everyone is watching to see what is going to happen here. There's just as many people on the fence in this case as there is in Delphi. And Delphi has way more concrete evidence, okay, on both sides. We've got both sides coming out and admitting problems in Delphi. We've seen it. We've been seeing it. This stuff just isn't making sense to anybody. So there's eyes on all of this. It's not a red herring, sir. You are known all over the world. That's not a red herring. People call you Santa Claus all over the world. That's not a red herring. That's the freaking fact. That's a fact. So when it comes to this whole thing, I mean, I understand sort of what they're saying. And I'm pretty positive that they touched on this in the beginning of this, and he's just like reiterating it again. I mean, I understand. He wants it to be there, but the judge is ready to be like, okay, let's hear your argument, Ann. I'm curious. Let's hear what you got to say. So that's coming. And that's going to be an interesting argument, because if Bill Thompson's only argument to keep it there is, oh, the publicity is a red herring, meaning that and to him, the publicity is not a problem. It's not truth and factual, which is a lie. All right. Not true. Then that'll be an interesting argument, because it doesn't really seem like Bill Thompson has a real good reason. But if Ann Taylor can present something factual, the publicity, she can't use that either. She can't use the publicity either, because this is known everywhere. Everywhere. But they do have, like, they should try to see if they could do it there. That's just how the law kind of works. But I kind of hope it gets changed, just because it's something that we've kind of all expected so far. Now, the judge made a comment, and I was sort of actually a little bit confused, because I thought, and I'm not into the political stuff, okay? I mean, not like when it comes to jurisdictions and the way that courts and stuff move around, okay? I don't know anything about that crap, okay? So when they're talking about the change of venue, judge says something about how he doesn't really want to be in another county for X amount of time or whatever. So whenever they change venue, the judge doesn't change. I thought it was like reassigned to another judge. But the way he said it was like he don't want to be traveling. So if somebody could clarify that in the comments, that'd be great, because I really thought that it was like they assigned a whole new judge because it's a whole new county, and I might be wrong
about this. The issue is whether the publicity and the nature of this case is such that we cannot pick a fair and impartial jury in this county. And of course, we know that just being aware of publicity about a case does not disqualify a juror.
Yeah, that's true.
There has to be a showing that that publicity or whatever has impacted the juror to the point where that juror cannot sit in this box as a fair and impartial juror and make a decision based only on the evidence presented in this courtroom. That's the issue that Your Honor is going to have to decide on the change of venue question. And you can't do that based on a bunch of affidavits from experts who say, Judge, there's been a lot of publicity.
Yeah. I mean, he's not wrong. Because what publicity is the one taking the most effect here? Is it mainstream, who are being like hella biased, even though they claim to be completely unbiased? Is it mainstream publicity that they're worried about? Or is it people here on social media who are asking all of the questions? Because one of those benefits them and the other one doesn't. And it sounds like he's worried to me. So it makes it seem as if, to me, he's more worried about what's going on in the internet publicity wise than it is mainstream. Because I feel like if the mainstream was what he's thinking about right now, he wouldn't be saying, oh, it's not a big deal. I don't know. Maybe I have that backwards. Maybe he's saying it's not a big deal because the mainstream he thinks is the more effect. I don't know. They've had such like a quote unquote hard on, okay, for like TikTokers and YouTubers and people that talk about this stuff on social media. So I feel like they constantly are trying to like pass the buck on to us whenever it's them. Like, we're literally just reacting to what they're telling us. We are reacting to what they're showing us. If they don't like the way that we are acting about it, then they need to fix their approach. Plain and simple.
That doesn't cut it.
It doesn't cut it.
So I think just having a state's discovery deadline and trying to prematurely move forward with motion for change of venue is not the right approach. We think that the proposals that we make are reasonable, understanding that Taylor has concerns about whether she's going to be able to meet those. And I think there are enough stages in there that if that becomes a reality, there's the opportunity for us to discuss that. Like everybody here, we only want to do this once.
Do you?
We do not want to invite error that we can avoid.
Yeah, you do. You like them billable hours, bro.
Thank you.
Thank you, Mr. Thompson. I think you said maybe you're like 98% on
But probably a little bit more than 95% is what Ms. Jennings just told me.
Okay. So if it's 95%, I mean, is it possible that it could be done before the end of August?
It's possible.
Look at his face. He's just like, what you mean, bro? You need 6 months for the additional 5%? That doesn't even make sense. And it doesn't make sense. It doesn't make sense at all. If they are 95% of the way, then that means that they definitely were not ready to go to trial in October. Okay. And that's another thing that's really just been aggravating me and keeping me in on what's going on in this case, because they were ready to fry him, take him out, all the things. Okay. Back in October, whenever it was supposed to be like an actual trial situation, they were ready. They said they had everything that they needed. They were good to go. No problems. But we also saw that with the Pharaoh scanning. They told us the house was good to go. Everything was scanned. The house was irrelevant. It was fine. It was fine. And then Bryan waives his right to a speedy trial. And all of a sudden they're like, oh, hell, now we've got time to do it right. We can go back and spend even more of thousands of dollars worth of tax money on bullshit that's not needed. They went back and Pharaoh scanned the house after it had been gutted, moved around, all kind of stuff happened into it. They did it a second time saying, oh, now we can complete it? What you mean now you can complete it? The house is in shambles. Way different than it was the first time it was scanned. And the first time it was scanned, it had been taken apart at that point a little bit too. They were ready to put this man on death row with incomplete evidence. And just like we heard, they only had one date for the cast. So you're telling me they only presented the grand jury that apparently indicted this man one date of the cast report, and it's not even the freaking date of the crime. It's the date that the WSU officers actually put eyes on the car, the 11/29. The whole thing is just wild to me that they were just so prepared to be just like ready to go. And they had nothing. They have all complete information. That should scare the shit out of everyone. Every single one of you should be angry about that, man.
And we aren't going to wait till the end of August to do anything. We will continue to disclose information as we receive it. I mean, that's not fair to the defense. That's not fair to anybody. Just sit on stuff and dump it. So we are hopeful that it'll be finished by then, but we don't want to have to face a deadline that we think there's a chance could be difficult to meet. And that's why we propose the early September date, which would be essentially 6 months from now.
September 6th, that's what you're saying.
What's the difference between end of August and early September? A week?
Taylor, you said that would be fantastic.
That would be fantastic, Your Honor. And Your Honor can give us a January 2025 deadline if the court wants to set a discovery deadline for us too. Expert disclosures, I think maybe would take a little bit longer, maybe February.
So the state wants end of August, early September, and she's like, okay, cool, but I want months and months later on in January of 2025. Holy crap.
January of 2025, the court gives us a deadline for expert disclosures. I want to comment on the motion for venue change. Your Honor, because I filed a motion and the court doesn't have affidavits or the briefing to understand how we're going to approach this, doesn't make it untimely.
Okay, honestly, I'm not happy with the way that she did this either, because she's like, oh, just because I didn't put all of my supporting documentation in this motion that I filed for the change of venue doesn't mean that it's not relevant. Yeah, actually, you should have done your homework. Like, you're sitting here complaining that the state isn't handing you everything that you want, that there's incomplete information, but then you're filing incomplete information. Don't be a freaking hypocrite, Anne.
I'm fully aware that the massive amount of media coverage by itself isn't all of it. But I'm also aware that this case has had more media coverage than most other cases, and it continues. So there is an impact of that. There are other considerations besides just the massive amount of media and an impact on potential jurors. That's what we're going to talk about. I think it's timely. I think it's appropriate to set a change of venue motion. I think it is what makes the most sense for the court to make that determination and set a trial date from there. If the court sets one here and has to change it later, a lot of things have gone into play to get that trial date set here, to get the courtroom reserved, and a lot of people realize.
I don't disagree with that, though. I don't disagree with that. It'll be really shitty for the families who have already been trying to, like, get this over with. They want all of the evidence put in front of them because they are just in the dark as everyone else. And if you guys, look, those conversations between Brett Norton and Steve are disgusting. They're disgusting. Like, people want to sit here and complain about the fact that people like me and a few others will come out here and say something about things that the families say, the way that the families act, and act like we're the bad guys because we have an opinion based off what we're seeing given out to the public. Brett Norton was literally trying to pound conspiracy theories into Steve's head. Okay, they should be more worried about the people that do that kind of stuff than they are about the media and the publicity, because the media and the publicity is what's being spoken to the public directly in the masses. Okay, people like Brett Norton honestly deserve to go to jail for interfering with an active investigation, because we're going to go over the messages. It just really aggravates me because I understand what Anne is saying, but I also am like, we need to get this done because the families are literally getting stuff from every which way. It's driving them freaking insane. And we've only seen one piece of it. Now, I know a lot about what's going on in the background and the whole Brat situation with the TikTokers and all the bullshit, okay? But that's just one conversation between one idiot and one of the families. Can you imagine how many there actually are? How many things like what she was telling him were just thrown at them constantly? And that's just Steve. There's multiple people in Kaylee's family. There's multiple people in Maddie's family. There's multiple people in Xana's family. There's multiple people in Ethan's family. All of these kids had multiple family members and friends galore. Can you imagine the effed up freaking conversations that some of these psychopaths here on the internet that send me and all these other creators these intensely ridiculous, stupid emails in all caps and different fonts and different colors and all their freaking craziness? Could you imagine what they're sending the victims' families? This needs to get done and over with. But I understand her point. You don't want to get there. You don't want to get the family's hopes up because they are begging for a trial date. They're begging for everything to be put out in front of them so they can try to get some closure and see what the hell is going on. You get right up to it and you're a couple weeks away, and then you can't do it because you screwed up and the jury pool is completely tainted and you didn't change the venue like you should have. But what if they end up having to change the venue more than once? Has that ever been a thing? I guess that's something I would love to research. If there's ever been a situation to where the venue was changed, but then it did no good and they had to end up doing it again like multiple times. I mean, honestly, that probably will happen here, you know, because it's the Idaho 4 case.
Waiting until the court has heard the information, more than affidavits saying there's mass amount of media coverage, the court can make that determination. If the court agrees to change venue at that time, then it makes a lot more sense to just set that trial from there. I would think by the end or by May, when we can have a hearing, I would think I would have a better handle maybe on the process the state's going through now with its discovery. I will continue to make the utmost effort to get all the way through every piece of what I have now and continue to follow up with questions to the state so that we can try to have this discovery issue put aside. Once we have the discovery completed, I think that we're going to have a lot better idea of what the motion practice is going to look like and how long that's going to take. And it'll be a more realistic way to disclose experts to one another with the materials that's required under Idaho Rule of Evidence 702. I think that's a better way to go, even though you might not set a trial date today, because at least you'll set one that's really informed that maybe everybody can rely on.
Thank you. Well, I'm gonna make an informed decision about changing venue, and it makes sense to me. I mean, it may be premature, but I'd like to see what the defense has to say about that, what you're going to present. So, I'm just curious.
See,
Here,
he's just curious. He wants to know what their argument's going to be. So even though it's probably irrelevant and he's probably going to end up denying it and they're probably going to go ahead and try to seat a jury in Latah County any freaking way, this again is redundancy, wasted tax dollars, more billable hours for literally no reason, and more time being wasted on unimportant things. The only thing that matters is the truth. The only thing that matters is the freaking evidence. The only thing that matters is if the evidence is true and solid and it actually points to Bryan Kohberger and only Bryan Kohberger, okay? Because that's what they're trying to claim here. All of this other stuff is just fluff. The system, the whole judicial system needs a complete overhaul. This is all just crazy. Honestly, with the way that things are now, and this is like a little bit of a sidetrack, okay? But the way that things are now, why does it have to be a jury of your peers? Like, why does it have to be people in your local area? Like, with the way the technology is now, let's say something happened in Texas, okay? Why can't they choose, and say it was a death penalty case, okay? Why couldn't Texas choose another death penalty state, choose a county in that death penalty state, and it not be anyone that's a peer, no one that has anything to do with Texas politics, with in anybody that could possibly like know the situation that far in, like a completely random place, and do this all online? Do it all online. You have a jury that is in a whole nother state that doesn't have anything to do with your state. There's no biasness. It's literally like fresh and completely unrelated. I don't understand this whole, oh, it has to be a jury of your peers. Whenever you're just talking about a small town case prior to the internet, there were issues even then about things being misconstrued and jury pools being tainted. Why does it always have to be your local area? I feel like in this day and age, there's definitely other ways they could do these things. I'm just saying.
I can always deny it, but
He probably will.
If it's
Money.
sufficiently strong and persuasive, then maybe it makes sense to do that. And obviously, when just for personal reasons, I particularly want to go to another county for 12 weeks or 2 weeks.
See, this was my question I had earlier. When he's saying this, so he will go to another county, but he doesn't have jurisdiction in other counties? Or does he have jurisdiction in other counties? Like, I'm guessing it has to be like granted. I would love to know that whole process. I'm going to find out because I'm curious. I really want to know now how that works. Like, what's the paper trail process? Because there's a paper trail for everything.
Necessary. I mean, we'll do what we need to do, but I'm not, as I sit here, I'm not persuaded that we necessarily have to change that. declarations, affidavits, whatever you're going to do, let the state know that who is going to testify. If you're going to have witnesses to testify, presumably experts. We got a taste of that, sometime at the beginning of one of our hearings. So,
You mean Vargas? You got a taste of what Vargas might have said on the stand, meaning you got a taste of what could come out on the stand, which means you got a taste of the fact that somebody will have the balls to get up there and say what needs to be said about the bullshit. Yeah, you got a real big taste of that, didn't you?
maybe I'll hear the same witness. I don't know. But,
Not the same witness, I don't know.
so we'll
Yeah.
say April.
I'm pretty sure he was questioning that when he read the document and saw Vargas's name was not on there. I feel like he's trying to hint at things. It's just my opinion.
17.
Yes, I can make
Okay.
that.
And maybe we say the state has enough time to have their response by May 1st. What do you think?
That's-
Okay.
I think that's appropriate, Your Honor. Thank you.
Okay. Because there may be experts on the other side too. So, and I expect the information that you're going to present both sides and with the brief. So obviously.
Yeah.
You actually have other cases. I'm surprised.
All of a sudden it's silent. Did he even press a button to mute the microphone?
How do you feel about
No, just
afternoon?
weird. Okay.
That's a little bit far out, but we've already been talking about maybe having a trial starting in June. So,
Your Honor, can I have it before May 25th? A witness I anticipate is not going to be available starting May 25th. Starting May 25th, I think, for 2 weeks. So if I could have it ahead of May 25th, that way we
have
can.
a jury trial that week, May 20th. This afternoon of May 14 give you enough time, Ms. Beatty?
That was May 14th, Your Honor.
May 14, that's Tuesday.
Yes, Your Honor.
Okay, we'll say, how about 1:30?
Sounds great, Your Honor.
So 1:30, May 14. I am going to make a determination about that presentation on change of venue before I set the trial. It could still be March 3rd. Yeah, that's 2024. I know. I'm just still thinking of 2024. But it's hard. It is hard to think it. It's so far out. But I'm listening carefully to both sides. And
he really does have an issue with it being so far out. That's one thing about this that has not changed from the last session to now, from January 26th to now. He is like, why, guys? Why are we having to push this out for an entire other freaking year? He's saying that to both sides. Like, why are we doing this? Why are we waiting so long? I mean, I get that. I mean, I want everything done correctly, especially knowing that they were lying as hell, trying to say they were gung-ho and ready to go whenever they have nothing. Like, if they're at 95% today, okay, February of 2024, what was the percentage of discovery back in October whenever we were supposed to have the real trial? Curious.
And it's a complicated case, and it's a death penalty case, and that adds a lot of really does. We're going to have a deadline of September 6th for discovery from the state. And Ms. Taylor, did you say beginning of January?
Yes.
Okay, January. Give me a date.
Give them longer.
There's been an ongoing discussion beginning most recently with the state's request for scheduling order, and I believe Ms. Taylor briefly addressed it at the last hearing. There's been an ongoing discussion about the alibi deadline, and the state is asking the court to either limit the defendant to presenting evidence about the disclosure that he made related to the alibi, which was that he was driving around the night of the homicides, but not allowing any further discussion or evidence of an alibi, given the amount of time that has passed since the state requested that alibi disclosure. Alternatively, since it was in the court's scheduling order initially prior to the trial getting vacated, we would ask the court to set a 10-day deadline now, because that is consistent with the alibi statute. The state does not believe it is appropriate to tie the alibi to the jury trial date in this case. The statute that sets forth that 10-day timeline is completely separate from Rule 16 and other discovery deadlines through the litigation process. I think at this point, there has been so much time that has passed, and it has frankly causes the state great alarm that the defense is discussing calling upwards of 400 witnesses during the innocence phase when we don't have, potentially don't have a full alibi disclosure.
I mean, she's not wrong. To say that you have 400 witnesses, but you've literally only said, oh yeah, he was driving around. Now, from what I recall, it was like before midnight until like whatever time. I don't really know if they got into too many specifics, but I remember it saying something like before midnight. And in the PCA, it's trying to say that he left his apartment like around the time that Kaylee and Maddie were blowing up Jack G's phone, which is like creepy enough in itself. Okay. It is crazy for them to say that he was basically just driving around by himself in the middle of the night, but then say they have 400 witnesses to like say that he's innocent. What would cause somebody who's just driving around in the middle of the night to have 400 witnesses to say that you're innocent? Now, an alibi has to be validated. He can't just say, oh, this is what I was doing, and then expect for them not to expect concrete proof. So if he can say, yeah, I drove around this direction and I turned on this road and I was in this town and I went here and I went there, and they can piece together surveillance cameras, that's one thing. But for them to say, oh yeah, we have 400 witnesses, that is a lot. That's a lot of freaking people for someone who's a loner, doesn't have friends, and was driving around by himself in the middle of the night. I'm just a little confused on that.
And when you look at cases regarding appeals from issues that arise during alibis that come up at trial, these cases are all defendants appealing a conviction because the state doesn't get a second chance. If the state gets ambushed at trial, that's it for us. We're asking the court to hold the defendant to a fair alibi deadline, and I think that the time has come. Thank you, Your Honor.
Yeah. Well, my understanding was that was it, but I may be wrong.
You are wrong. Hold on. We talked about this because on the January 26th date, they stated they were still working on getting more of the alibi. So them now, the state now coming in and asking, okay, you said there's more. So we're, over a month past the time that you told us in the courtroom that there's more and we haven't gotten more. I don't have a problem with the fact that the state's asking that. Now, I know that the burden is on them to prove that he is guilty, but it's also part of it that you give your alibi. So I agree with the state saying, okay, well, if there's more and we're being told that there's more, we need that more. Because if y'all are going to be demanding stuff from us, then we want what you're supposed to give us too. That's how you do this fairly. There's nothing wrong with that at all.
Vacated the trial setting. The court vacated all of the deadlines, including the alibi deadline. In this case, it's more than Bryan was just driving around. We have let the state and the court know that we expect that will be supported by expert testimony and by cross-examination of the state's experts. I need their full cast report and the rest of the discovery related to that before I can say more about that. So
I don't agree with that. I don't agree with that at all. And I've never agreed with this. I've had a problem with this from the freaking beginning because they've been claiming that Bryan's alibi will be proven when it comes to them cross-examining the state's people. When it comes to what the state has being given to them, then they'll give the alibi. That's not okay to me. It's not. If you have an alibi, Mr. Kohberger, one that you can validate and prove, freaking hand it over. Hand it over. The state cannot put holes in an ironclad alibi. If his vehicle, and it is proven to be his vehicle, is on other surveillance footage in other locations other than where they're trying to claim it was, that can't be misproven because it's going to be a fact. It'll be a fact. It'll be a proven fact. So I don't agree with them saying, oh, we're not giving you an alibi until we see everything you got on our client. And then we're going to work our way around your stuff to prove his alibi. No, I don't agree with that whatsoever. Sorry, not sorry. I don't.
To tie me to a deadline when I don't have the rest of the discovery that I've been waiting for that would relate to that will mean that
if he has an alibi and he can give you proof that it is more than just driving around, so why the hell are you having to wait for them to hand over what they have before you then show your hand? All of this like hypocrisy is disgusting. It is. And people can get upset with me about this all they want to, because I know there's a lot of people that are like, oh, it's on the state to prove guilt. Okay, but there's also rules that are having to be implemented here. And for this to be a fair trial, both sides have to follow the rules. Okay? You can't just let one side get away with being an asshole and not doing what they need to do simply because of your own biasness. That's not how this works. And that's the biggest problem with the internet. Because I'm already seeing like a lot of people being like, oh, why does he have to give that to them? Why are they asking for this, but they won't give this over? But it's always so one-sided. No, both sides have to abide by the rules. The state cannot sit there and complain about something that they're not getting, but then also not be handing over to the defense what's needed. Same thing with the defense. They can't sit there and boo-hoo and boo-day about what they're not getting while still sitting there and not wanting to hand over what they're supposed to be doing either. It's just so annoying. It's so freaking annoying. But I don't agree with Anne saying that she has to wait for what the discovery is in order to then hand over Bryan's alibi. If Bryan has a real ironclad alibi, then who gives a shit what the prosecution has, right? Am I right?
In the court to reopen it. My expert can't finish until I get the rest of the discovery as well.
And the discovery you're talking about is a video of the car?
No, I am.
What do you?
So the video that we talk about is one that I think the state's going to use in its case that I don't have full video on, that I'm not talking about any video of Bryan's car.
I'm not talking about any video of Bryan's car. The prosecution is still working on a video. That's another thing I don't agree with. If the prosecution has a video that shows something, why are they having to piece it together? It should be in its nature, in its natural state, in its original state, all that's needed. That's going to bother me until we get to trial so that we can see actually what they were piecing together. But because to say, oh, they're still piecing the audio and the video together, what are you creating? A blockbuster film? Like, why are we doing all of this? Why are you having to piece it together? Shouldn't it just be? I mean, seriously.
When I'm talking about an alibi defense, unless there's video that shows it elsewhere that I haven't gotten to yet, which may be possible given the fact that there's a lot I haven't seen yet. What I'm talking about, though, is the cast report.
She seems really fake. She does. She seems very acted. She seems very fake. I don't really get that from Thompson. He's like an old man and he just don't really care, right? So he just gets up there and he talks. I don't agree with either side, okay? Just like with politics, both sides suck. Both sides suck here too, all right? But Anne just seems like she's faking it. I guess the whole fake it till you make it thing.
The drive testing information.
Cast report meaning the identification of the particular car.
That is the cell tower information.
What? What? Judge. Where have you been, honey? Where have you been?
So what that is going to show and what the drive testing data is going to show and what other reports related to that.
Drive testing data. Drive testing data. What does that mean? What does that mean?
Are going to be things that my expert needs to finish our investigation and things that I need to formulate my cross-examination against the state's expert. So when I'm telling you that I'm going to do those things in Alibi, I can't tell you more than that right now, but that's how we're going to support Bryan's alibi, that he was out riding that night.
Okay, so you're saying that you have not received the cell tower reports?
I have some data. Some cell tower data, some phone record data. I have a draft of a cast report. The most recent information I have cast is the FBI doing their work. The most recent information I have is that on March 31st, they expect for that report to be done through the peer review process. So I may get it a month from now.
See, March 31st, which is a whole month from now, is whenever they're expecting the cast to be completed. So then what in the shit was actually presented to the grand jury? How can Judge sit there and deny the motion to dismiss the grand jury indictment knowing what we know? Okay, because I'm looking at this as a layman and being like, hold on now. The state doesn't even have everything that they need. There's no way that they presented complete information to the grand jury. How can the judge not see that that's a problem? How can the judge sit here and hear her literally saying that the cast is just a draft? That the only date that she's gotten is one date, and it wasn't even the date of the murders themselves, and that it's still not going to be ready and in her hands until probably, according to her, the end of April. And then not dismiss the grand jury indictment. Get to the real trial to where both sides can come out and present what they have. This is just so insane that he's not seeing the problem here.
I need to get it to my expert to digest. There's materials that support their report that I don't have full disclosure of. And the state's aware of it. I think they're working on it. And maybe they're on that drive that I'll pick up today, but I haven't had them yet.
So you expect to get that in mid-March?
I expect to get their report after March 31st after it's done. The supporting data, I'm not sure when it's coming. They tell me it's coming.
Okay, I'm going to kick it back to the state.
Your Honor, I guess I'm a little confused because if
I obviously am too. So
Yeah, because you don't even know what cast is.
Because if the defendant's alibi is that he was out driving around that night, I'm not sure what additional information his cell data could add to an act.
And that's a whole nother thing. That's a whole nother thing. They told us in the exhibits for the PCA that Bryan Kohberger's phone itself was not on the freaking network when it came to the time of the crime. So what is the cast data going to show? Honestly, if his phone was completely off network, if there was no way that his phone was actually bouncing off of any towers, utilizing any data whatsoever, then neither side really have an argument for the cast. They really don't. And if Anne is sitting here saying, oh, well, we've only seen 1129, does that mean that the actual cast report is going to have a huge missing piece for the actual time of the crime? Because they can't use it for anything. Yeah, cool, his phone was off network. I know that seems a little freaking fishy. Okay, it's sus. I understand why people think that. I totally get it. But they can't use something that doesn't exist. They can't use the lack of data in order to prosecute or defend, honestly. Neither one of them can. So really, I'm confused about what this whole argument's about. If his phone was not on the network at all, and they've already told us that for over a year now, then what is the cast really going to show when it comes to the time of the crime? Because the time of the crime is all that matters. Even if he is some sort of weird little voyeur or some little creepy little stalker, unless they can prove that he was there and in that house and then walked back out that house or ran back out that house and all of the things, unless they can prove that, then all of it doesn't matter. None of it matters.
Actual alibi defense. It seems like what the defense is asking for, and they're being completely upfront about it, and I appreciate that. But what they're asking to do is
they always do these like backhanded stabs. Like Anne will be like, I'm not saying anything bad about Bill Thompson, but I'm not saying anything about the state not actually, like, I'm not saying that they're withholding stuff from us on purpose, but like, it's just funny to watch.
Is essentially double check all the discovery before disclosing their alibi. And that's not what the purpose of an alibi deadline is.
I agree.
In fact, it's quite the opposite. There is case law that describes that given the ease with which an individual can fabricate an alibi, and certainly that's not what the state is accusing the defendant of doing. I'm using language that is in case law, though.
Stabs.
Given the ease with which an individual can fabricate an alibi, that is a very legitimate deadline. It's a reasonable deadline. It's a reasonable demand of the litigation process. There is a reason why there is a 10-day deadline in the statute, and that is because
they don't want it fabricated.
Is able to tell his counsel where he was that night. They can work together and formulate a defense, and they can disclose an alibi. That is the whole purpose of an alibi deadline. The state has complied with the discovery up to this point. We will continue to comply with discovery. We are disclosing everything that we have to the defense when we get it, unless there's some protective order issue. We are asking that the court hold the defense to a fair standard that has been set forth in the statute and that is constitutional under the United States Constitution and the Idaho's Constitution, that has been repeatedly upheld by the United States Supreme Court and the Idaho Supreme Court. Thank you.
Okay, I maybe dropped the ball, but went through the cracks that I didn't. I guess what I interpreted that as that was it for.
Because again, he didn't listen. Anne stood up on January 26th and said that that wasn't it, that there was more coming. Listen, Judge. Listening skills are super important.
What we were going to hear about where he was and how he was established, the evidence that he
Exactly.
was in a particular
It has to be a
place.
proven alibi, not just spoken.
So once again, trying to be compromising, I'm going to give you until April 17th. You can submit the
That's the-
other information that you need to find
That's a long time.
and that's
So April 17th, which is, by the way, the day before my birthday, is whenever he has to finalize his established alibi. Hopefully they don't wait that long, but I bet you anything, if it does get filed, it's going to be sealed. We're not going to know. We're not going to know.
should be plenty of time
Till trial.
because you're going to get some additional information from FBI apparently by mid-March. And we can talk more about that later at the hearing on the motion for change of language. So that gives you some cushion. I'm not going to set it for 10 more days, but I am setting that. And the reason for that is so we don't have an ambush at the trial. I mean, that's why that is established as a law.
For both sides.
Okay.
Has to be fair.
Well, I think we've gotten somewhere.
Do you?
And is there anything else we need to address today, Mr. Thompson?
I don't believe so, Judge. Thank you.
Okay, Ms. Taylor?
No, Your Honor, thank you.
Okay, great. Thank you all. We are adjourned.
Okay. That is the end of it. But we are going to revisit something. Because I didn't really quite hear this. I thought I heard it, but I wasn't quite sure whenever I was listening to it the first time, because I was trying to listen to it live as much as I could. And I'm doing 20,000 things at one time. Okay. When I'm listening back to it in edit, I definitely heard it. Now I'm going to play this. Tell me what you hear.
You may remember a few hearings in the past that the state from the very beginning said there was no, that played no I don't know how to even, it wasn't, when I asked them in the hearing, that did you use the IGG, any of the information of the IGG to get the warrant, to get Mr. Kohberger's DNA?
Let me slow it down for you.
Did you use the IGG, any of the information of the IGG to get the warrant, to get Mr. Kohberger's DNA?
One more time.
To get Mr. Kohberger's DNA.
And another one.
Mr. Kohberger's DNA.
Okay. Does it not sound as if he is almost slipping up to say the last name Kopacka? Now, I have talked about Kopacka. I have not done all of the really crazy deep dives that a lot of channels have when it comes to Brent Kopacka and that entire, what people are believing to be a swatting situation. And honestly, there's a lot of really strange crap going on there. And even if for some reason and somehow that whole situation is not related to this situation, what happened to Brent Kopacka is a travesty in itself if you take the details and separate them from this. But it's even worse if there is some sort of connection here. Now, what happened to Brent Kopacka happened in Washington. There is literally no reason whatsoever for this Idaho judge to even have Brent Kopacka's last name on his mind when he is sitting there talking to Bryan Kohberger. And a lot of people caught this. I see it's going all over Twitter. People are like, how in the hell are we supposed to just ignore what we heard here? And I don't think you can. I don't think you can. And it's not like we were trying to hear it. It came out of his mouth and it pretty much just like stunned everyone because we weren't expecting it. They've been acting as if everything that has been entertained here online, that we're all just freaking, quack jobs. Okay. But then we have the judge literally like slipping up and saying Kohberger. Okay, well, what possibly could be going on in order for this Idaho judge to even pay attention to that name or have heard it enough or said it enough in order for it to slip like that? So this is going to be something that's going to cause a bunch of crazy because we all heard it. We all heard it. And I don't know if they can fix that. I don't know. I don't know what it means, but did you guys hear it? Like, leave me a comment and tell me, am I hearing things? Are all these thousands of people on Twitter talking about this hearing things? Or did it really happen? Did it? And honestly, it doesn't help that he's sort of like tongue-tied before he even makes the slip. He's not in his brain able to figure out quick enough how to say what he's wanting to say, which is just, just something else that just makes it really, 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 really strange. Okay. But that is it, you guys. This was a long one. I think this is probably the longest video that I have posted as of now. Yeah. And it took me forever to actually find the pieces because of the situation. Okay, so like I mentioned, I was going to let you guys know at the end of the video what actually happened with all the like electricity stuff, okay? I don't know where the hell I put us, honestly, because the other day I posted that the electricity and stuff went out, not this past time, like I just said a couple days ago, whenever the hearing was, but like about, I don't know, 2-3 weeks before that. The electricity and the internet seemed to go out at the exact same time. And I think it's because they're doing some sort of like construction stuff across the way. Because when it happens, we are like one of 7 houses that it affects. Like the house next door, the house next door, and the house across the street, and the house behind us all have electricity, and it'll be fine. But it'll be like sporadic, and we just happen to be like one of 7. So I don't freaking know. I don't know what in the shit is actually happening. I just don't. But the crazy part, this is what's crazy. When my electricity went out the other day, it was like 10:30 in the morning. And at that point, like the only thing that was on was computers and my lights in my office. That's it. That's it. There were no other lights on in the house. Nothing else was really happening. It was literally just like me, the only one actually doing anything. My laptop was not plugged in. It was on battery. I wasn't even using my personal computer because I didn't have to make any calls yet. And I was just like on here. So I don't know what happened, but the lights flickered for a minute. And then it took like 10-ish seconds or so for everything to shut down. But the weird part is that the outlet where my computers are plugged in stopped working, but every other outlet in the room, in my office, in my bathroom, and in my master bedroom, all the lights worked. All the lights worked fine. And in the kitchen, the stove and the fridge outlets were on. Nothing else. The other 2 bedrooms, the living room, the washroom, the other bathroom, the outside lights in the garage, the outside lights on the porch, literally everything was off. No electricity. Almost like an hour after that happened, while I'm waiting on these people to like hurry up and get somebody over here because shit's scary. Electrical crap I don't play with. I just don't. I don't. Okay. All of a sudden, everything stops working. And then I get messages from the electric company and the internet company that there's a reported outage in the area. And it's one of those things where we're one of 7 houses. So I don't know what the shit. So I finally called the landlord back and I threw a fit because not only am I not about to play, but the thing that I posted a couple weeks ago about how there was like this huge opportunity that came my way that I've been like really, really working for. Long story short, it's really, really difficult for me to own a house. My student loans make it just kind of difficult for me to be able to get a regular mortgage like through a bank because even though the monthly payment that they're calculating in isn't accurate to what I'm actually paying, because of the way that my IDR is set up, they have to calculate in 10% of my student loans, and my student loans are $63,000, right? For something that sits there collecting dust. All right. So they calculated an extra $630 a month into my DTI that I'm not paying because that's not the amount that I'm paying in, but that's how they have to do it. So it throws me out of the ratio of being workable for a mortgage. Well, the owner of this house called me and asked me if I was interested in buying it. And I would just need to come up with 10%. And it's like $13,000, which, it's not like it's chump change, but it's not horrible either. It's just going to take a lot of like dedication and hard work and paying attention and being strategic in order to get the down payment, which is what I'm doing. I'm hustling at this point, like even harder than I already was before, because that's awesome. No banks, owner financing. He's already ran all of my stuff. He already knows who I am. He already has my credit score. He already has my information, my income, all the stuff. So for him, after 2 months to be like, I think I'm going to go ahead and like sell a couple houses, and I'm going to go ahead and see if she wants to buy it. I was freaking ecstatic because he's only selling a certain amount of houses, and he's only giving the opportunity to select tenants to actually buy the houses once he puts them up for sale. So I was like one of a handful. So I mean, I don't know. We've only been here for a few months, and I mean, I pay my rent like 2 to 3 weeks ahead of time. Yeah, maybe, I don't know, a good impression, I guess. So when I called the landlord about the electricity, I was like, do I need to call the owner? Because at this point, like, if he really wants me to buy this house, I'm not about to do this with no janky ass electrical stuff. Not happening. Okay. So they hurried up and got somebody out here, and it turned out like 9 or 10 breakers popped, and it had nothing to do with me like overloading anything in the house. It's the actual electrical wire, like one of the big, huge ones that runs the house. There's something on it that's supposed to be stopping it from hitting this tree that's behind my garage, and the electrical guy was like, yeah, no, that's not going to work. So my electric company has to come out and fix it. So it could happen again at like any time because, like I said, I wasn't doing anything. Like, I wasn't cooking anything. The washer and dryer were not on. The only thing that was actually plugged in and working would have been the fridge, the Wi-Fi stuff for the internet, the security system, and my computers. And that's barely anything for this big old house, energy-wise. So I don't know, but that's what happened. That's what happened, and that's the updates on that situation. Regardless of all of that, I was able to get this video done. You guys saw that I went by the Othram Lab, or try to find the Othram Lab thing yesterday whenever we had to drive over to Houston for my daughter's appointment. That was a whole situation. Okay. I know there's been now a statement from Kaylee's family and Xana's family when it comes to what happened with this hearing absolutely going nowhere pretty much. And there's a new document. I'll get to that. But I want to know what you guys think about the hearing, about the 11/29 being the only date they have for the cast, which is shit. That's just complete shit. And what do you guys think about what he might have slipped up and said? Do you think he actually said Kopacka? Do you think he didn't say Kopacka? And what do you think these x-rays are all about? I'm curious. Because we know that it was pretty brutal. We know that it was really brutal. But the x-rays are specific. Very specific. So again, I'm wondering if they're looking for things that were broken, or if there's maybe like fragments of the murder weapon in the bones, and maybe that's what they're looking for. I don't know. Curious. But hopefully it all comes out in trial, and hopefully trial isn't 10 years down the road, because this is getting excruciatingly ridiculous. And if it's getting annoying for us, you know it has to be a million times worse for the families. But that is it, you guys. I want to know what you guys think down in the comments. If you like the way that I present this information and give my opinion, please do not forget to leave a like on your way out, and subscribe to the channel if you are not subscribed already. Go out and try to do some good today. See y'all.